everyone, a very warm welcome to our YouTube channel, the Indian Law and Legal Tips. I'm Sarthak Kaja, Senior Legal Associate at the firm, and with us we are pleased to have Mrs. Sushila Ram Verma,
Thank you, Sarthak.
Chief Legal Consultant. And to our viewers, I would want to say that banking sector has been on a boom right now, and we as lawyers felt like that there's a discussion that requires to be done upon the banking laws and all the laws pertaining to all the banking and transactions and everything. So, the SARFAESI Act is the one that comes to our mind when we talk about banking laws. And my questions would be pertaining to the said act. So, ma'am, with your permission, I would want to proceed with the.
Certainly, Sarthak. Let's go ahead.
So, ma'am, my first question would be very basic. What is the SARFAESI Act and why was it introduced in India?
Okay, now SARFAESI Act, let me clarify to the viewers that it is one of the banking laws. There are many banking laws in India, but SARFAESI has got a lot of prominence because of the very purpose for which it was enacted. Now, SARFAESI is an acronym and stands for Securitization and Reconstruction of Financial Assets and Enforcement of Security Interests Act 2002. A very long name or title for an act, and that's the reason why we all very fondly call it the SARFAESI Act. Now, this act was a need of the hour in 2002 because the Indian banking sector at that point of time was grappling with an alarming rise in NPAs and bad loans, and there were systemic inefficiencies in recovery mechanisms. Banks had lent money against secured assets. Yet, when they had to recover their dues, if the borrower did not pay, they found the entire process of recovering their dues through civil litigation very tiresome, very lengthy, and at times very frustrating. So, even after getting decrees, we have noticed in the Indian legal system that probably execution is the most difficult part of any litigation. Having said that, and after all these facts came before the legislature realized that it was extremely important to help the banking sector to have a strong enforcement mechanism, because of which SARFAESI was born. And SARFAESI now empowers banks and financial institutions to enforce security interests without judicial intervention. In simple language, it means if the bank has taken an asset as a security, the bank can enforce, that is, can sell the asset or take over the asset and do what it wants or what it feels would be prudent with the asset to recover its loan. And this can be done without getting into lengthy litigations. Now, the SARFAESI Act, being the kind of act it was, where it gave superpowers to banking and financial institutions, it was challenged as an ultra-virus act, and the matter came up before the Supreme Court of India in a very famous matter known as Mardia Chemicals versus Union of India, 2004. In this, the Supreme Court was pleased to uphold the constitutional validity of the act and recognized that SARFAESI was a legislative response to a grave economic situation that was created by mounting NPAs. The court observed that the act seeks to balance the borrower's rights with the larger public interest of financial stability within the country. Having said that, the act was upheld, and in essence, SARFAESI has brought some level of financial stability in the banking sector, and it has helped to improve the credit culture, reduce NPAs, and restore confidence in the Indian banking, legal, and ecosystem.
That was quite insightful, ma'am. You gave a huge overview of that. Ma'am, but I was wondering what was the legal position before the SARFAESI Act came in?
Yes. Now, Sarthak, a little while ago you were talking about the banking laws. Now, one of the banking laws that we should consider that came up before the SARFAESI Act was the Recovery of Debts Due to Banks and Financial Institutions Act 1993, which is also known as the RDB Act. And that act was responsible for helping banks to recover their loans. Now, this act also, because of many reasons, was not a super runaway success. In fact, the recovery process was very slow. There was a heavy pendency before the DRT, that is the debt recovery tribunals. There were procedural delays and there were enforcement bottlenecks, which forced the legislature to consider another law. SARFAESI fundamentally altered this model by allowing the lenders to bypass the court at the initial stage and direct enforcement of their rights over secured assets. Now, this I would say, Sarthak, is an extremely important aspect because, see, if you have an asset and you have to wait for, say, 10 years, assuming it's not a land, it's, say, plant and machinery, that plant and machinery would depreciate. So, what would you get after 10 years? It's a land, yes, one understands that it can appreciate, but not everything. So I would say that SARFAESI helped from a judge-driven recovery system to a creditor-driven enforcement mechanism, which obviously became a success. Now, the transformation has significantly strengthened the lenders' confidence because they were getting fed up with all the defaults that had happened in the Indian banking law, and we all know about so many of these scams that happened where there were big borrowers who borrowed thousands of crores of rupees and refused to pay. So, what I would say is that this act imposes a higher duty on banks to act fairly, transparently, and in strict compliance with the statutory requirements if they want to recover their dues right at the inception when a loan is declared as an NPA.
Ma'am, now that I understand this act is pertaining to lenders and borrowers, but which are those lenders and borrowers that fall within the scope of this act?
A good question. I think that's very important. So I would say this act applies to secured creditors. When we say secured creditors, you have taken a loan and against that loan you are giving some kind of asset. So secured creditors would mean primarily scheduled commercial banks, public sector banks, NBFCs, and any other financial institutions that may be notified by the central government from time to time. Now, the key requirement is that the debt must be secured by a tangible asset. That is when you come within the purview of the SARFAESI Act. Now, on the borrower side, I would say SARFAESI has a wide sweep. It applies equally to individuals, companies, firms, trusts, and other legal entities. The Act is intentionally broad to ensure that commercial reality prevails over formal distinctions. Now, one very important thing which I think I should bring to your notice is that SARFAESI consciously excludes certain categories such as agricultural land, small value loans, and unsecured transactions to ensure that enforcement powers are not exercised indiscriminately.
Ma'am, now that you mentioned about loan, ma'am, when does a loan actually become eligible for SARFAESI action? So, what is the importance of NPA classification in SARFAESI?
Very well said. Now, see, Sarthak, there are many people who have taken loans. There are many people who default. There can be n number of reasons for the default. It's not always motivated by reason that they want to be defaulters. There are times there can be a technical glitch. There are times that the banking system may not have worked the way they wanted it to work. And sometimes there may be genuine difficulties. So, what SARFAESI proceedings mean, or rather, what is the eligibility criteria for initiating an SARFAESI action is that the loan account has to be classified as NPA. Now, NPA means non-performing assets, but every account will not be non-performing, declared a non-performing asset or a non-NPA unless and until a reasonable amount of opportunity is given to the borrower. And all these loans, all these borrowings that have been done can only be classified as NPA if it is done in accordance with the terms and the conditions or the norms laid down by the RBI, that is Reserve Bank of India. Now, NPA classification is not merely a formality, it's the jurisdictional basis for which under which SARFAESI action can be taken. Courts have repeatedly emphasized that improper or mechanical declaration of an NPA can invalidate the enforcement process. So, technically, what this would mean is that if a bank goes rushing to court under a SARFAESI, it has to ensure that it has followed all the steps for declaration of a NPA. This safeguard ensures that borrowers are not subjected to coercive recovery merely due to temporary or technical defaults, where the intention is not to be a defaulter, but the default has happened by mistake.
Ma'am, as students of law, when we study about SARFAESI and all, we always told that Section 13 is the heart of the act.
Absolutely.
So, ma'am, is there a specific reason for that, or how does it work?
Yes. Now, Section 13 is extremely important. We are reproducing the section on the screen. Now, Section 13 is the section in which the SARFAESI proceedings actually begin. What happens is when you begin a SARFAESI proceeding, the first thing you have to do is issue a demand notice, and that demand notice is issued under 13(2) of the Act. Now, when the bank gives a demand notice to the borrower, a 60-day clear period is given to discharge liabilities. Now, the law wants to ensure that if a person is not a habitual defaulter, they should be given an opportunity. So, they are giving them 60 days in which they can discharge their liabilities if it is possible for them to do so. It's like, it's not just a warning. I would say it's a statutory opportunity given to the borrower to regularize the account or even at times renegotiate the restructuring or raise objections if the borrower has any objections. Now, if the borrower fails to comply, then Section 13(4) authorizes the drastic measures such as taking possession of the assets, assuming management of the business, or even selling secured property. That's the reason why Section 13 is so important. Over and above that, again, we are going back to Supreme Court and Mardia Chemicals versus Union of India. Like I said, very important judgment pertaining to banking laws. This recognized that Section 13(2) notice is a critical borrower safeguard and not an empty formality. Further, this point has been upheld in many other judgments like Travancore versus Union of India 2008. The court held that SARFAESI is an additional remedy available to secured creditors, but one that must be exercised strictly within the statutory framework. Because of these very extraordinary powers of bypassing the court, strict procedural requirements is a must and it's non-negotiable. Any lapse, incorrect notice, lack of application of fine, or even procedural irregularity can render the action unlawful.
Ma'am, one thing that comes to my mind is as lawyers, we have to think about both the parties, the lenders and the borrowers. Now, what comes to my mind is that SARFAESI Act is for the lenders.
Absolutely.
But when I think about borrowers, ma'am, so what are the real and enforceable rights that a borrower has under the SARFAESI Act?
Very good question. In fact, I'm glad you raised this question because, contrary to popular belief, SARFAESI does not eliminate the borrower's rights, it just restructures. Now, when I say restructure, it's because if a notice is served to a borrower from a financial institution, the borrower has 60 days in which he can make a representation or file objections against the notice. The bank is legally obligated to consider it and give us a reasoned reply. This requirement injects a system of fairness and accountability into what would otherwise seem to be a unilateral mechanism. Courts have very often held that a non-speaking or mechanical rejection of borrower's objections reflects arbitrariness and it can be set aside and it would actually vitiate the very proceedings. So I would say that a borrower has better rights under SARFAESI and they are not illusionary rights, they are procedural safeguards which are rooted in natural justice.
Ma'am, we're talking about recovery and recovery authorities and everything. Ma'am, at the end of the day, they are civil authorities, and if they are unable to recover their liabilities and everything, so what role does district magistrate have under Section 14? How does that enforcement work?
Again, a very important and a very good question. Now, when we say district magistrate or chief metropolitan magistrate, it obviously has criminal connotation. Okay, so when I say Section 14 is invoked when physical possession cannot be invoked peacefully. Now, you are a borrower and you have given me, say, a piece of land as part of the security against a particular loan. And I, as the banker, go to you and say, okay, you have not paid, your account has been declared as NPA, I'm taking over this land and I'm going to try and put it up for auction. And whatever money I get that is due to the bank, I will take from there, the balance I will give you. Now, there are many times the borrower will not take it standing down, right? So they will say, no, you can't do this. They will try to create an impediment. Sometimes they try to get gundas. Sometimes they try to threaten the people who have gone. So what happens is Section 14 is there, which helps the banks and financial institutions, where they can approach the district magistrate or the CMM, that is Chief Metropolitan Magistrate, take the assistance and in executing possession through administrative machinery. Importantly, the magistrate does not adjudicate the dispute. Their role is confined to only verifying whether statutory provisions have been fulfilled, that is the requirements under the Section 13. And this distinction is vital because borrowers oftenly feel that Section 14 is like a trial. No, it's not a trial. It is just the initial step which a financial institution takes when they are not able to take over a secured asset.
So now how does the DM enforces it?
Another very important aspect, and which I think all viewers should be aware of. Now, once the DM passes an order, then the magistrate can either personally take possession. When we say personally, means through his team or his office, or he or she can authorize a subordinate officer or even an advocate commissioner to take over possession. They can take the help of police if they feel that there is some violence that can happen or there have been threats. Apart from that, they can break open the locks if required and prepare a panchnama and inventory, all again to be done by the police, and then hand over physical possession to the bank. So ultimately, it's an order passed under Section 14, enforced through the mechanism of the police or through the office of the DM himself. Okay.
Well, ma'am, now that I think about it, it's a quite well thought out law, having all the
Absolutely.
procedures defined and everything.
Yes.
Ma'am, one thing that also comes to my mind is how effective is the remedy under debt recovery tribunal as for a borrower under the SARFAESI Act?
Sarthak, there's a difference between SARFAESI and IBC. They operate on different levels, though sometimes it's overlapping. Now, SARFAESI focuses on asset-specific recovery, whereas IBC aims at corporate revival or orderly liquidation. Once insolvency proceedings commence, SARFAESI actions are stayed due to the moratorium. Why SARFAESI? All civil litigations that are ongoing will get stayed because of the moratorium. Therefore, lenders often strategically invoke SARFAESI first to induce settlement or strengthen their negotiation powers. The coexistence of these laws reflects a graduated enforcement framework offering lenders multiple tools depending on the nature and severity of their financial stress.
Ma'am, as a senior person from the industry and you've been working for a lot of banks and all those NBFCs, so ma'am, would you say that the SARFAESI has been successful in creating a fair balance between lender empowerment and borrower protection?
Answering it very broadly, yes. SARFAESI was indispensable for restoring lender confidence and cleaning up the banking system and the bank's balance sheets because there were n number of NPAs. However, its success also depends entirely on a very responsible usage. You can't say that SARFAESI can be invoked at any point of time. There's a responsibility under the Act. Fulfill the eligibility, go for a SARFAESI action, but not randomly. Give the borrower a chance to make good whatever is in terms of paying the installments or whatever. If that doesn't work, then go to court. But it doesn't allow you to go immediately, right? There is a step-by-step method. So courts have consistently held that powerful statutes demand a very disciplined execution, rightly so. Otherwise, there would be anarchy. Any abuse or overreach undermines not just the borrower's rights, but also the legitimacy of the banking system. So I would say that yes, SARFAESI has achieved a fair balance between the lender and the borrower, and it should continue because it has achieved a lot of results.
Ma'am, now a lot of our viewers are people from different industries, and there would be situations when they are served with a SARFAESI notice. They are
Absolutely.
borrowers. So, as a lawyer, what would your advice to be to these people?
Now, if you are a borrower facing a SARFAESI notice, there are certain rights that you have. Because this is a very extremely important question, we are also putting the answer on the screen and the viewers can see it. Now, the first thing is you have the right to file a securitization application. You can file an application under Section 17 before the Debt Recovery Tribunal. However, you cannot challenge the initial 60-day demand notice in court immediately. You can approach DRT after bank takes a measure under 13(4), such as taking symbolic or physical possession of the asset. Also, you must file the application within 45 days from the date the bank takes possession of your asset or you get a possession notice. So ultimately, there is a certain system that has been set and you have to follow. Then there are grounds for challenging the bank. The DRT doesn't look at whether you owe money, it looks at whether the bank followed the rule book. So, common grounds for a successful challenge include non-compliance of Section 13 with that is, if you send an objection to the 13(2) notice and bank does not respond within 15 days or does not give you valid reasons for rejecting your objection, then the DRT will look into this and they'll probably set aside the entire process. There are, however, procedural flaws. Failure to publish the possession notice in two leading magazines or failure to serve the notice to the borrower or the guarantor personally. Again, that can also be SARFAESI process can be set aside. Asset valuation. If the reserve price for the auction is set significantly lower than the market value, then also the DRT can take some action. Also, one very important aspect which I feel we should point out here is MSME protection. Now, recently the judicial trends have shown, and including not only judicial, even RBI frameworks emphasize that where a borrower is registered under the MSME, banks are expected to consider the applicable restructuring and rehabilitation guidelines before resorting to SARFAESI action, failing which the action may be tested on the grounds of arbitrariness. So this is another very important thing that viewers should be aware of. Also have what is known as the redemption trap. It's because of a Supreme Court judgment that came up recently in 2025. Now, as per this, what earlier borrowers used to do is they would wait till the last minute before they pay back the loan or before the sale was confirmed. But now the Supreme Court has said in M. Rajendram versus KPK Oils 2025 that your right of redemption is extinguished the moment the auction notice is published. So you cannot wait till the 10th hour to go and say that I want to buy the property. See, this is a way of safeguarding the financial institutions. This had become, whenever there is a grey area or whenever there is a possibility of manipulating the law, there are many borrowers who don't have any ethics and they try to make the most of it. So this is what happens in many cases. So if you intend to pay the full amount to save your property, please do it before the bank publishes the auction notice in the newspaper. Once it's published, dear viewers, you will not get a chance to go and participate in the auction. This is an extremely important aspect of SARFAESI and you must be aware of it.
Ma'am, as a mentor, how would you conclude the whole discussion?
Now, Sarthak, I personally feel that SARFAESI Act remains the most powerful direct action tool in the Indian banking system. It's very effective because it bypasses all those slow-moving civil courts that allow banks, that make banks wait for years and years. And like I said, if it's land, the value still goes up. But what happens when it's a factory or when it's a something like that, or where it's machinery, plant and machinery, these depreciate. So I would say it's extremely important, the SARFAESI Act. Now, you have somebody who's been declared as an NPA. He has taken a huge loan against plant and machinery, and you notice that the plant and machinery every year is getting depreciated quickly. So the best is take possession and sell it to whoever wants it. That way at least you can make good your losses, right? So, as of 2026, its effectiveness is characterized by high speed for individual recoveries, but definitely there are complexities when the IBC also comes into the play. That's when SARFAESI stops to become a strong law. Now, the core strength, I would say, of the SARFAESI Act is that recovery without courts, which means faster, quicker, and simpler. Then also the success rate is much higher as compared to other modes of recovery. And also there is a deterrence because the borrower also feels that no, if I don't pay and these guys go under SARFAESI to liquidate my asset, what then? So I think there's a deterrence factor also. And I would say recent legislative changes and Supreme Court rulings have further sharpened the act. For instance, now there are lower thresholds for NBFCs. Pursuant to central government notifications issued under 21M of the SARFAESI Act, now NBCs are also permitted to invoke SARFAESI for loan accounts as low as rupees 20 lakhs. So it gives them a good chance to move ahead. Then extinguishment of redemption rights, which I had explained earlier. Once the auction notice has been published, a borrower cannot go and join the auction and try to buy back the property. Then cooperative banks are also something that can now be given some kind of breather. The Act now fully covers cooperative banks, giving regional lenders the same recovery muscle as national giants like SBI. Now, Sarthik, since you asked me to give my comments, I'll also say there are some limitations and challenges. The first and probably the most is the IBC pause button. When I say IBC pause button, I mean that the minute moratorium is declared, everything goes for a 6. So that's a very big handicap for any law, not only SARFAESI. Then I mentioned depreciating assets, like if it's plant and machinery or it's a car. I mean, if it's some mechanical thing, like for instance, trucks that you have purchased for your business. Then another drawback is the overburdened DRTs. They're not able to cope with so many recoveries that are pending. And one good thing about the SARFAESI Act is that it excludes agricultural land, which remains till date a very sensitive issue in India. So in that sense, I would say this is a good thing. But if it's misused, then obviously it's not a good thing. So I think with this, I'd like to pause and say to the viewers, dear viewers, if you have taken a loan, be honest in your intentions, repay your dues in a timely manner. Why get into all this? Why not just make your life and the bank's life simpler?
Thank you so much, ma'am. It was a delight to have you for such a deep insight into the subject. And I'm sure that a lot of our viewers got educated on the subject. And all I can do is that it makes us curious to study the subject even more. I would like to thank your valuable inputs. Really helps us, and I'm sure that a lot of us got educated on the subject in a way that we didn't know that this SARFAESI Act works in India. And I would also want to request for all the people who like this video to share and subscribe, because your addition really helps us produce more quality content. And it was a delight to have you, ma'am.
Thank you. And at this juncture, I'd like to thank all the new subscribers. The fact that we have so many subscribers now is very heartening. And thank you. And please help us to spread the word. It is our aim that we want to spread law to the common man. Thank you.
Stay tuned for more such videos.